video is about the compliance checklist under the Factories Act 1948.
Completely proven that in absence of a law किसी का भी easily exploitation होना बहुत ज़्यादा ही easy हो जाता है. There is a probability that factory workers को भी ये चीज़ को face करना पड़े if they are working as a laborer in a factory. So the Factories Act 1940 Act was enacted in order to amend the laws regulating labor in factories. It is basically a social legislation which aims to ensure the safety, health, welfare of workers working in the factories. It regulates the working condition, covers aspects like fixed working hours, safety standards, employment of young workers, and leave provisions. This act assigns responsibility to factory owners for maintaining a secure working environment for these people.
Now, according to the Factories Act 1948, the factories must be registered and obtain a factory license under the Act. The license is renewable upon its expiry by applying the respective state labor department or department of factories. To get the license, the occupier must send the notice under Section 7 of the Act and at least 15 days before he begins to use the premise of the factory as a factory along with the list of the things mentioned in the screen, that is the name and the situation of the factory, the name and the address of the occupier, the name and address of the owner of the premises or building, the address to which communications relating to the factory may be sent, the nature of the manufacturing processes to be done in the factory, the total rated horsepower installed or to be installed in the factory, the name of the manager of the factory, the number of the workers likely to be employed in the factory, the average number of workers per day employed during the last 12 months in case of a factory, and any other particulars as may be prescribed. Now, can you imagine what are the possible consequences of not achieving good standards of health and safety in a factory? Well, there can be numerous of consequences. It can lead to an increased risk of injury or even death. And workplace injury can not only put an employee out of the work, but it can immensely impact their life as well. So there are certain health provisions provided in the chapter 3 of the act to ensure safety and health facilities for the employees in the factory. It includes maintaining a clean environment for the working conditions of the workers, and the factory shall have proper arrangement for the treatment of wastes and effluents. The factory's premises should have adequate ventilation and free air. If the work is carried in a factory is such that the dust and fumes are released in substantial quantities, then effective measures should be taken to prevent its accumulation in any workroom. If the humidity is increased artificially in a factory, then the water used for this purpose should be taken from the public water supply or should be purified before it is used. No room in any factory shall be overcrowded to the extent that it becomes injurious to the health of the workers employed in that factory. And the working areas of the workers and the passage should have adequate and sufficient light, natural or artificial or both, whatsoever is available. There should also be safe drinking water supply for the workers and also urinal facilities to be provided to the workers at the time of the work. There should be separate urinal facilities for both male and female, and every factory should have a sufficient number of spit-ons placed at a convenient place and it should be cleaned regularly. Health provisions. There are certain safety provisions provided in the chapter 4 of the act, like there should be fencing of the machinery, and if it becomes necessary to examine any part of the machinery while the machinery is still in motion, then such tasks should be done only by a special trained adult male worker wearing tight fitted clothes. And if there is a necessity to work on a dangerous machine, then it shall be done while taking all the precautions and shall only be allowed by a person who is in knowledge and has the experience of that using that machine. And if there is an appliance, uh, should be and there must be an appliance that should be provided and maintained to move driving belts to and from the loose pulleys in the factory. There should not be any self-acting machine that should be kept in a space over which a person can pass. And every set of screw, bolt, or key in all the machineries used should be installed in a factory effectively to prevent any danger. If there is a revolving machinery used in the factory, then it should be permanently affixed to a place and there should be a notice indicating the minimum safe working area around the machinery. If a factory is using any machinery which is operated at a pressure above the atmospheric pressure, then the pressure should be kept under the check to ensure the safety. All floors, stairs, and the passages should be maintained and properly constructed. If there is any vessel, tank, or pit in the floor which may be a source of danger, it should be securely covered or fenced. No worker employed in the factory shall be made to carry or move any load which might cause an injury to him. If any process is being carried out in the factory which involves a risk of injury to the eyes from particles or fragments, suitable goggles or effective screens should be provided to the workers who are working in such circumstances. No person should be allowed to enter any confined space until precautionary measures have been taken to remove if there is any fumes or gases used in the factory. There should be precautions taken regarding the use of portable electric light, like no portable electric light of more than 24 volts should be used in any confined space or chamber or tank. All the precautionary measures should be taken to prevent explosion of the gases. If there is an inflammable dust or explosive used in the factory, and the factory should take all the practical measures to prevent the outbreak of fire and its sprays and its spread in case of in a fire arises. The building of the factory should be maintained properly so that it does not cause any injury to the health of the workers working there. Chapter 5 of the Acts provides for welfare provisions to be provided to the workers. For example, washing facilities. There should be separate and adequate facilities to be provided for both male and female workers, and the facilities should be clean and conveniently accessible. The factory should also provide a suitable place for keeping the clothes not worn during the working hours and for the drying of the wet clothes. The workers who are obliged to work in a standing position should be given a proper sitting arrangements during their rest hours. And there should also be first aid boxes containing all the necessary contents to be maintained and provided during all the working hours. If the factory has more than 250 workers employed, then minimum one canteen should be provided and maintained by the occupier. A factory having more than 150 workers should also provide adequate and suitable restrooms and lunchrooms with provision for drinking water. If the factory employs more than 30 women workers, it should provide a suitable room for the use of children under the age of 6 years of such women. If a factory has more than 500 employers, such number of welfare officers should also be employed as may be prescribed. Working hours is not only a boon for the workers, but it can also effectively improve the work to be carried out in the factory. A person should not be allowed to work for more than 48 hours in a week, and a person should not be allowed to continuously work for 10 consecutive days without any holiday. If a person is deprived of the weekly holiday, he should be allowed to take that holiday in a month or 2 months as compensatory holidays. A person should not be allowed to work for more than 9 hours per day. And if a person works for 5 hours without any interval, he should be provided an interval to take rest. The hours after the midnight, if a person is working in night shift, it should be counted in the previous day. And there should be prohibition of overlapping of the shifts of the workers. Extra wages for overtime. If any worker works for more than 48 hours in any week, he should be entitled to the wages at the rate of twice of his original rate of wages. And there should also be a restriction on double employment. That is, a worker should not be allowed to work in a factory if he is already doing work in one. There should also be a notice of periods of work for adults. A notice should be put every day clearly showing the periods in which adult worker may be required to work that day. Every factory is also required to maintain a register of adult workers showing their names and the nature of the work of that worker. No worker should be allowed to work any work other than the mentioned in the notice and the register. Certain provisions provided for employment of young persons under Chapter 7 of the Act. It states that no child who is less than 14 years of age shall be allowed to work in any factory. An adolescent should also not be allowed to work in a factory unless a certificate of fitness has been granted to him under Section 69 of the Act. A certifying surgeon can issue a certificate of fitness to an adolescent only when the manager of the factory and the guardian of the adolescent sign a document that he will be employed in that particular factory. No child should be allowed to work for more than 4.5 hours in a day and should not be allowed to work in the night at all. Every factory should display and maintain a notice every day for the period during which the children will be allowed to work. A register should be maintained in the factory mentioning the name of the child worker, the nature of his work, the group in which he is included, the shift of his group, and his certificate of fitness. No child worker should be allowed to work in a factory unless his name is entered in the register of child workers. And no child should be employed in the factory otherwise in accordance with the notice period of work for children displayed in the factory. Act also provides for annual leave with wages. Every worker who has worked for 240 days or more in factory in a year should be allowed to have leaves with wages in the subsequent year. If a worker who has taken leave under section 79 or 80 of the Act, he shall be entitled to wages at a rate equal to the daily average of his total earnings for the day during the month immediately preceding his leave. And there is a provision for payment in advance in certain cases. A worker who has been allowed leave for less than 4 days in the case of an adult and 5 days in the case of a child should before his leaves begin be paid the wages due for the period of the leave allowed according to the provisions of this act.